you. That's
Yep.
Yep. There we go.
There we are.
That works. Right.
I'll keep my mouth shut until it's time.
All right, do you want to get the door? Great, thank you. Okay, I think we'll get things started now. Thanks everyone for coming along to another Foley Institute Coffee and Politics. In just a second, I'm going to ask the Dean of the College of Arts and Sciences, Donald DeWard, to introduce our speaker for today. But before we did that, I just wanted to run through a couple of logistical issues. If any of you need to sign in for extra credit, those sheets will be available after the event today out the front of the Foley Institute around the corner, so you can go there. And we have two events for next week that I thought I should let you know about, and they are Vanessa. Oh, no, she's gone. There are events. We have one on international disaster relief communication, and that is going to be on Friday. This is a representative of an NGO called INSTEP, who is going to be talking about how you work in disaster areas in terms of communication and getting relief work there. And that's going to be on Friday at noon. And on Thursday, we have the Washington Attorney General coming in to talk about campaign finance, which some of you may be interested in that, considering the recent initiative on GMO labelling and the lawsuit that followed that. He's going to be talking about those issues on Thursday. And that's also here at noon, so hope to see some of you then. But without further ado, let me turn over to Dean DeWard. Thank you.
So it's a real pleasure to see all of you here. Good for you for turning out on a Friday. Even though there is pizza, it's good to see you here nonetheless. So it's a real pleasure also to have Chief Justice Barbara Madsen here. So she is currently serving her second term as the 55th Chief Justice of the Washington State Supreme Court. She was first elected to the Washington Supreme Court in 1992 and was re-elected in 98, 2004, and then 2010. Justice Madsen received her undergraduate degree, easy folks, from the University of Washington in 1974, and then she's a ZAG. She earned her JD from Gonzaga in 1977. Previously, Justice Madsen has worked as a public defender in King and Snohomish County, counties, and the Seattle City Attorney's Office, where she was appointed special prosecutor. Chief Justice Madsen has chaired the Washington State Gender and Justice Commission since 1998. She's also received many awards, including that of Seattle University School of Law Woman of the Year. As a Chief Justice, she's committed to continuing the Supreme Court's longstanding support for access to justice. And we welcome you here and thank you for coming back to the issue.
Thank you very much. Thank you. Thank you so much for inviting me back. I have been to the Foley programs in the past, and I've always gone away energized. So thank you for being here and giving me a boost to go on with my work back at the Temple of Justice in Olympia. So I was asked today to talk about the role of an independent judiciary in the Washington constitutional system. So that is my topic, and what I thought I would start with is the obvious, that the judiciary is a co-equal branch of government in a three-part system of government, which of course is true at the federal level as well as at the state level. But I do recall my days. I was a political science major. I'm sorry it was at the UW, but I did have a daughter who graduated from here, so I am a multi-institutional believer. But in my days as a political science student at the University of Washington, it didn't I didn't notice so much at that time, but looking back, there was almost no discussion of the courts, that branch of government which is the judicial branch. Of course, you'd hear the big opinions like Brown versus Board of Education. You might hear about Roe versus Wade. But you didn't hear the politics of the judiciary. And I think that's still probably true today, though here I am. So perhaps things are a little bit different at the Foley Institute. But when I did look through your magazine recently, I didn't see any other judicial members who had spoken. So I think it's probably still pretty true that we, in the political science arena, look at the other two branches, not so much the judicial branch. I think if we recognize that we don't pay a lot of attention to the judicial branch. It's usually at the federal level, right? So you hear about Roe versus Wade and you hear about Brown versus Board of Education. How much do you hear about the state judiciary? Not anything, most likely, other than what you might read in your newspapers. And yet, about 90 or more % of all the business of the courts goes through the state court systems. So the state courts are actually the most important judicial branch in our tripartite government. The state courts is where the action is. This is true in part because most of the issues that the state Supreme Courts decide are state law questions, and those do not get reviewed by the U.S. Supreme Court. So the final decision in most of what we have come in front of us is made by the state Supreme Court, not by a federal court, and certainly not by the U.S. Supreme Court, which only takes about 50 cases a year out of the thousands of cases that petition for certiorari. So why don't we talk about the courts when we talk about political science, when we're teaching a very important subject like our form of government? Why is the judiciary so left out, or so much the stepchild, if you will? Well, I've thought of several reasons why this may be true. Partly, I suppose, because we are nonpartisan. We are also at the end of the ballot. When you take your vote, you get to the end and you're already tired, and there's a bunch of names that you don't have a clue who these people are, so you don't vote. Also, we can't be lobbied, though people try. I get lots of emails telling me how I ought to decide cases. But in fact, I can't read those emails, and I can't be lobbied. So that's another reason why perhaps courts aren't seen to be so important in the political system. But I also think there's another aspect, and that is that the court's reach and authority is not fully understood. And it's not understood by the public, but it's not understood by the other branches of government either. And sometimes I think maybe not even by the judges themselves. In the past, in part, I think that this, the statement I make about the judges maybe not even understanding themselves what their role fully is and what the reach of their authority is because I think that the role of courts has been evolving and continues to evolve. And that is in part because the way that judges view their role has evolved and continues to evolve. And it's also in part because when a case comes to us, it takes anywhere from 2 to 3 years to be decided. And so people don't have a lot of patience. We are broadcast on TVW, for example, and at the end of the program, TVW gets a call and says, well, how did it come out? Well, TVW says you have to wait about 6 months to a year before we're going to be able to tell you how it came out. So people don't have a lot of patience for that. And if you want political change, you want it fast. You don't want to have to wait 2 to 3 years. So I think that's perhaps another reason that the courts just don't, the profile has not been elevated to the same level as the executive and legislative branches. And also, I think this is an important point, courts generally have been restrained in their exercise of power. And it's actually a doctrine of judicial restraint. Many of us practice it, some of us don't. But many of us practice it, and what it means is that you answer the question in front of you in the most narrow way that you can so that you don't overstep. And the overstepping that I'm talking about is more than one boundary. But the boundary I'm talking about most importantly is that separation of powers between the branches. And so courts restrain themselves mostly because they don't want to transgress that boundary between the other branches of government. So what is the court's role in our state? And that's really what I'm here to talk about. And I would say across jurisdictions, the role of the Supreme Courts across the country is pretty similar. We are supposed to hear and decide cases. We rule on constitutional questions. And we also administer a vast network of municipal, district, general jurisdiction, and appellate courts. Here in Washington, we have about 480 judges at these various levels of court, and the Supreme Court is to try to bring some organization and some consistency to these courts across the state. But also, the role of the state courts varies across jurisdictions based in large measure upon their state constitutions. And I think until probably 15 or 20 years ago, many people had forgotten that we even have a state constitution. But we do. We have a state constitution which is quite different in many ways than the federal constitution. The history of Washington's Constitution is really closely tied to the politics that were extant at the time that we became a state, which of course makes sense. But this is looking out at sort of at the national scene in 1889. Not that I was there, though I saw my picture and I thought I could have been there. But in 1889, there were a couple of things that were influencing states that were coming into the Union. Jacksonian democracy was really at its height. And Jacksonian democracy, I'm sure you all probably know better than I do, but it's sort of the elevation of individual rights and the individual over the system. And so that's one of the influences that was extant at that time. Another was sort of the onset of the progressive era, the reformers, and these trends really helped to formulate the thinking of our founding drafters. That also helped to shape the judicial system that our drafters put into place. In addition, there was another really interesting thing that was going on across the country, and that had to do with the rise of the Catholic educational system across the country. Prior to Washington's entry into the Union, there was actually a move afoot to change the federal constitution to make a provision that state assistance or that would prevent state monies from going into Catholic education systems. There was that effort to change the federal constitution failed, however, and so as a fallback, what those in Congress who were interested in the issue, what they did was to require states coming into the Union to have those provisions around education and keeping education non-religious, and all of these states coming in, including Washington, were required to pass educational provisions in their state constitutions. Also in Washington, I suppose partly looking at sort of those influences that I've just mentioned, the population, and particularly those drafters of the Constitution, were very mistrustful of their legislature. And I think the other factor that I didn't mention was big business coming west. The railroads, there was a huge mistrust of railroads and corporations. Things haven't changed that much, except the railroads that aren't so much of a threat anymore, but big corporations maybe tend to still to be a big threat. So there was a fear that the legislature would be in the pocket of big business and in the pocket of the railroads. And so they really, our founders really put a lot of faith in the courts. They wanted the courts to be elected. They wanted their judges to be elected so that they would be responsible, and they felt like that was their protection from the vagaries of the legislature. How does this mistrust manifest itself in our Constitution? A couple of ways. One, we have the initiative process. Another, we have a referenda process. And that's really an opportunity for the people to override their legislators. Another provision which I think has come into play quite frequently recently, that is Article 1, Section 19, which essentially prohibits the more than one topic being encompassed in a bill. Now that sounds kind of benign, right? But it's not benign at all. It was designed to prevent something called logrolling. So logrolling is the practice of adding to a piece of desirable legislation, or adding desirable provisions to a piece of legislation which has many unpalatable provisions. And so this makes it more likely that it will pass. And so what the early drafters thought was important was to preclude that from happening and have everything stand on its own merits. And so we have Article 1, Section 19, which precludes this practice of logrolling. So that's our Constitution. Fast forward to contemporary times. Although I became a judge in the 80s, and probably a lot of you weren't born yet, so I may not feel too contemporary to you, but I feel it's contemporary. And that is to look at contemporaneously how does how do these factors impact the role that the courts play today. First and foremost, my topic has to do with the independent judiciary and how that fits into this whole governmental process. And so looking at that today, it's more important than ever, in my view, that we have an independent judiciary. In recent times, that has become much more of a concern, particularly because we have an elected judiciary. Now, I'm not going to talk about elected judiciaries versus retained judiciaries or appointed, because that's like a full hour unto itself. But it does impact the role of the courts. Recently, judges have come into the crosshairs of big money and big interest groups. And unfortunately, our judges tend to be a little naive about politics. Some of them, of course, were political scientists, such as myself, but most were not. They went into the practice of law, and I don't think they ever thought of themselves as becoming politicians. So they're naive in the ways of politics. And because they can't horse trade. They can't give for getting. And so it's very tough when a judge has to run for election. And so they're an easy mark. They haven't got a good way to raise a big war chest, for example. So they're an easy mark for big money and for big interest groups. The other I think that has given rise to this phenomenon of being in the crosshairs of big money and advocacy is because elected officials have become so much more partisan in recent decades. And with that, little gets done, right? So where are you going to turn for something to happen? You're going to turn frequently to the courts. This is particularly true in an advocacy for advocates, but it's also true for big money and lobbyists. So in some states, not so much in our state, at least not recently, they have really had problems with the influence of big money. Iowa being probably the most recent, where 3 of their justices were defeated, and essentially because big money came in, ran a campaign. The judges were like deer in the headlight, and they were all lost their seats. And I think the other thing about the rise of the importance of the courts has to do with the fact that judges, as I said, we're evolving in the way we think about our roles. Well, I think the evolution has been that judges have become more and more convinced that our role is to stand between big government and the individual, and that is to vindicate individual liberties and to vindicate constitutional rights for the individual. For example, when I came into law school in the 70s, almost all of our jurisprudence around equal protection was based on the federal equal protection model. And that basically, for those of you who don't know what equal protection is, generally the courts will uphold legislation. It's kind of the given is that difference between the branches. We respect each other's roles, and we give deference to the legislature when they pass laws. And one of those areas of deference is in equal protection. So does a law give more benefit, for example, or more burden to one particular group of people than another? And when I came to law school, we really looked at that in the same way the federal courts were looking at it. We said, well, if there's a rational basis, if you can think of any reason that the legislature might have had in its mind when it passed this legislation, then there's a rational basis for the legislation, and it's fine, and we uphold it. And for decades, the courts were upholding legislation in the face of equal protection challenges. But I would say about 15 years ago in our state, we started looking more skeptically at the rational basis test. And we found ourselves going back in time to a time closer to statehood, looking for the thread of equal protection under our own state jurisprudence. So we started looking for our own roots. And we found our own roots. And our own roots don't allow you to just imagine some reason why the legislature might have thought this was a great law. In fact, there has to be a real reason why the legislature passed this law, and it has to serve a substantial purpose. And it has to be, there has to be a reason to treat people differently, in a nutshell. So this is an example of the courts taking their role, or seeing their role a little bit differently. That is to protect the individual against the many, the majority. So in addition to these factors, there have been some other things that have happened as far as judges' view of their own role, and those have been some cases from the United States Supreme Court. One, Citizens United. Those of you who probably know something about the United States Supreme Court's jurisprudence recently, they passed or they decided a case in which they said essentially there's limits on campaign financing are not constitutional, and so basically there are no or few limits to what people can spend to get judges or others elected. The other was a case called Republican Party versus White. And this reaffirmed that judges have the right to free speech. Well, it's a right that most of us judges don't want. We want to keep our own counsel because that's how we ensure that we have an independent judiciary. It's not only that you have a real independent judiciary, it's that people think that it's a real impartial judiciary. But if you're starting to talk about your own personal views about politics, how would you feel as a litigant going in front of a court where the judge had already announced his or her view of a particular issue that might, in fact, who knows, someday come to the court? So these cases were not viewed favorably by the judges, but they do influence the way we see ourselves and how others see us and why our profile has begun to rise in the political structure. These are challenges, of course, to the independence of our courts. And probably the biggest challenge is really what judges do for a living. What we do is we protect individual rights against big government. And how does this happen? Well, for example, we have the initiative in the referendum rights, which I mentioned earlier. We have struck down as unconstitutional a number of very popular initiative and referenda, including the MVET, which was the Motor Vehicle Excise Tax Initiative, which reduced the cost of every license tab to $30. We struck that down as being in violation of our state constitution. We had a property tax lid initiative, which limited property tax rise to 1%. We struck that down as unconstitutional. Parts of 601, which is the initiative that sends every tax measure to the voters. We struck down part of that. Now, these are very popular initiatives. 60% or more of the population voted for these, and so we that did not make us very popular, as you can imagine. And that's just the state initiatives. So then we have local initiatives that we have also struck down. For example, the big one is a ban on fluoride in the water. There were local initiatives to ban fluoride in the water. Lots of very strong feelings about this. We struck that down. We also struck down a ban on, and this is even bigger, red light cameras at your local intersections. Many municipalities tried to run initiatives to ban these red light cameras. Struck them down. All, of course, because they violated our state constitution. And, of course, I would be remiss if I didn't talk about the McCleary decision, in which we said that the state was not adequately and constitutionally funding state education. That did not make us popular at all. Earlier I mentioned judicial restraint and the evolving view that we have of ourselves as a branch of government. And so judicial restraint, in the case of McCleary, we were accused of throwing it to the wind because we kept jurisdiction over that case, and we continue to have jurisdiction in the McCleary case so that we can ensure that the legislature will fulfill its responsibilities to provide a constitutionally adequate education for the children of Washington. But I can tell you that that was not very popular, nor were any of the other initiatives that we struck down, our act of striking them down, not very popular. And so what happens as a result of that? Well, we have legislation like we had this last session trying to reduce the Supreme Court, once from 9 to 5, and the other was from 9 to 7. We've also had a number of budget issues which have been decided against us, and very openly as a result of our McCleary decision. So the role of the court as we see ourselves has evolved, but it is not without a lot of pushback from the other branches. And it's understandable because the legislature acts in the interests of the majority, and they see themselves in that role as taking care of the public policy, public needs. But the courts, on the other hand, feel that we are the champions of the individual. And so there's naturally going to be a tension in those two roles. Despite this, the courts need to continue to be the watchdogs of liberty. And I think about this particularly with the developments that we've seen at the national level. Since 9/11, what do we have? The Patriot Act. We have the NSA, which we know what they've been up to recently. We have drone technology and GPS technology, which we know is being considered, at least, if not being used by local government. And we certainly know that our privacy is on the edge, I should say. And whether we continue to have privacy will depend in large measure on how the courts interpret the statutes that are passed that allow the surveillance that has been allowed. I read recently in an NPR report that there are, in Chicago, 10,000 surveillance cameras in the city that are public surveillance cameras, 3,000 at Ground Zero in New York. And I guess nationally, what I read was that there are 30 million surveillance cameras in use in the United States. So we do know that our privacy is at stake. After the Boston Marathon, congressmen, particularly from Massachusetts, but other states as well, asking for more surveillance cameras in their communities because of the fear that was stoked by that incident. In our state, and that's why it's so important to have a state constitution, in our state we have enhanced protections for individual privacy. We have interpreted our Article 1, Section 7, which is our equivalent to the Fourth Amendment against search and seizure, the prohibition against unlawful search and seizure. We've interpreted that as being more stringent than the Supreme Court of the United States has interpreted the Fourth Amendment. So we actually offer more protections. So this is an example of how central the role of the courts is in being able to protect those individual rights, including your right to privacy, in ways that the United States Supreme Court has not been able to do. Speaking of the United States Supreme Court, another role that I think is very important for state Supreme Courts in particular is that the United States Supreme Court in many very important issues, in many important cases, has really looked to what the state courts are doing. An example of this would be in the arena of gay rights, another in the arena of affirmative action, and also in the area of indigent public defense. I thought it was interesting that the state of Washington guaranteed free counsel to indigent defendants at the time that we became state. We had a statute that actually provided for counsel at public expense for those who were indigent and faced the huge the machinery of the state. It was not until the 1960s that the United States Supreme Court came to that same conclusion. But what the role is of the state courts is to build a consensus, and that's what the Supreme Court is looking for. In many of these cases, including in the area of gay rights and affirmative action and indigent public defense, they have looked to see what are the states doing. We are, in many ways, the barometer or the bellwether for how the rights that we as individual citizens in this country, how we can expect to view our rights and what kind of protections our rights are going to be given. So we've served this very important role for the United States Supreme Court, though frequently we're not acknowledged, but it is a critical role for the development of almost a common law of expectation for individual liberties. So that is really, in a condensed version, the role that I see courts playing in a tripartite state government with a very different and very unique state constitution that gives our citizens many more rights than perhaps citizens in other parts of the country might have, based in part because of our history and the time in which we became a state, but also just on our spirit. The things we value in this state and in our communities is a little different than perhaps in other states in other parts of the country. So that is your state Supreme Court in action, trying to preserve your liberties. And I think I have exhausted my time for remarks, but I want to open this to just a kind of a lunchtime discussion among friends. Yes.
I have several questions. Actually, I have a lot, but I'm only going to ask.
Okay.
In your opinion, do you feel that we still have a federal constitution and that the federal government follows it? That's one question.
Well, we have a federal constitution, of course, and who is it that's following it?
I asked, do we still have one?
Well, I look at the Supreme Court's decisions, and It's evolving. There are people who would say, there are people on our Supreme Court who think that the original meaning is the only meaning that can be given to our Constitution, and yet I see by some of the recent decisions by our U.S. Supreme Court that they don't believe that. They actually think that there is a difference in the rights that we perhaps had when we were founded as a nation and the rights we enjoy today. And I say that in particular in connection with the Second Amendment, because for a decade, but for a century actually, the Second Amendment was interpreted to be relative only to a militia, and now the Supreme Court has decided that it's relative to individual self-defense. So I think we still have a Constitution. Its meaning is somewhat fluid, as I personally think it has to be, but and I think that people are always pushing the limits. Congress pushes the limits. Individual advocacy groups push the limits. So we have a Constitution. It's up to the people who are interpreting the Constitution to defend it.
Well, if it's fluid, then are all laws fluid, that we can interpret them any way we desire? And also, is there a severability clause in the Constitution?
There's no severability clause in the Constitution.
So then it's an all or nothing item, isn't it?
It depends, really. You're talking about two different things. You have, okay, excuse me, if you want to an answer. Statutes have severability clauses. And so if a statute comes in front of the court, and the court is deciding whether or not a statute is constitutional, the court will then decide if some portion is not constitutional. If it has a severability clause, then the court might sever that unconstitutional provision and let the rest of the legislation stand. So that's how severability works.
Let me ask you one more question about one of the things that the state Supreme Court did, and why. He said that the Washington State Supreme Court voted down the ban on fluoride and red light cameras. Is that correct?
What we did was to find that the the local initiative in those two, on those two issues was not permitted because the state itself had reserved to itself the authority to legislate in those two arenas. And so we struck those down because they violated the Constitution in the sense that the primacy rests with the state legislature, not with local jurisdictions. Local jurisdictions are what's the word I'm looking for? They're subject to the legislature itself because they are creations of the legislature. So they were not given the authority to pass those kinds of initiatives, and that's what we basically said in those cases.
I may have misunderstood you. So you voted to say to the state that they could not pass bans, or they could pass bans?
When I was talking about those two areas, I was talking about local initiatives like county initiatives or city initiatives. And that was, the state did not give them the power to pass those kinds of initiatives, is what I said. And we reaffirmed that in our decisions.
Okay. So is there a state?
I think maybe I'll move on to somebody else, if that's okay. I understand you have a lot of questions, but these are students who'd like to also participate. Yes?
So I had a question about how you interpret like the Constitution, because there's people that talk about like a direct meaning of the Constitution, like just what the words say, but more like the spirit.
Mm-hmm.
So how do you like go about interpreting that in those separate arenas, I guess?
Well, that's a really good question. And it's sometimes it's phrased as an originalist theory. That is, that the Constitution means exactly the same thing it did when our founders passed the Constitution, and it doesn't change in any way. And the words, of course, don't change, but its application changes. And so a really good example of that is in the area of GPS technology. So I don't know, probably 10 years ago, a case came to us, and I got the writing assignment, and it was about a police surveillance of a vehicle using a GPS system. And they attached the system to the car, and then they traveled with this individual for about 2 or 3 weeks and knew everything about where this person had gone and how long they'd stayed there and whatnot. So So they really did know quite a bit about this person, but they didn't have a warrant to do that. So the question was, do they have to have a warrant? Now, certainly our founders were never faced with a GPS technology, right? So what would you do if you were the founder? Well, you know, who knows? So I have to think about, well, what's the spirit of the provision that protects people from an unlawful search and seizure which has not been authorized by an impartial magistrate, making sure that you have probable cause to intrude into this person's arena of freedom. So I have to figure this out, and so I wrote for the majority, and I wrote two things. I wrote, one, it was a trespass because they put the GPS underneath the bumper of the car, but also that it wasn't just a trespass, that it actually violated the expectation of privacy. The reasonable privacy expectations of the people of the state of Washington is that they're not going to have a bug put on their car. And so it was not just the physical intrusion, it was actually the spirit of the protection is broader than just the physical intrusion. So then fast forward, I think it was 2 years ago, maybe a year ago, but at least a year, the U.S. Supreme Court had the same question come to them. GPS, put on the car, same thing. Justice Scalia wrote the lead opinion. And as far as he would go was to say it's a trespass. He would not say that it was an intrusion into the reasonable expectation of privacy. But many of the other people on the court did say that in concurring opinions. They agreed with him that, yes, it was a physical trespass, but beyond that, the spirit of the protection was such that you would not expect the government to do this without a warrant. And so they decided it the same way, but on narrower grounds. And I think it's very much because Justice Scalia is one of those people who believes that, you know, the Constitution is only as it was written in, you know, 1776 or whatever year it was, because there were so many documents, I lose track of the year. But that's a point of view that I think, particularly when we look at state constitutions, that's not viable, because state constitutions in particular were intended to be frequently amended and are a governing document, a document that you can actually pick up and use when you govern. And if you can't change it frequently, and if you can't see that it changes with the needs, then it's really of very little value. Yes?
Okay, so I'm probably even more naive than about political science and stuff than the judges you described at one point. So I guess I'm going to ask, I understand there's this push for consensus building. And do you think that that's one of the functions of the judiciary? Was I correct in saying that?
Correct, in the sense of the U.S. Supreme Court doing that. But state Supreme Courts don't look for consensus in that same way, because we are only looking within our own borders. But the U.S. Supreme Court is making law for the entire nation. So that what they're looking at is, well, what are the states doing? Mm-hmm. One really great example was, I can't remember the name of the case now, but it was the case that the United States Supreme Court said that sodomy laws could no longer be enforced. And what they did was they went through all the states in the United States, and they looked to see how many states, A, had sodomy laws, and B, how many were actually still being enforced. And they found that no state was enforcing them, and that most states had taken them off their books. So they said, well, there's a national consensus around this issue. And so then they said, consenting adults in the privacy of their own home may engage in whatever sexual conduct that's consensual that they wish to engage in. So that's an example of using national consensus around a gay rights issue, which is essentially the right to practice homosexuality in privacy of your own bedroom.
Okay. Well, actually, the question I was wanting to ask is about the independence of the judiciary.
Mm-hmm.
And I'm a big fan of that. That sounds wonderful. But it struck me as what you were talking about earlier. You know, it's like if you get emails telling you, maybe you should decide this way for X reasons, X, Y, Z. I don't know the mechanism you use to not read them, but you say you don't read them so that you can hold your own counsel. And so I wonder how this actually promotes the independence. Because I'm imagining a case where if I had a ton of money and I could influence elections the way I want, I find people who, on their own counsel, choose the way I want them to choose. So it seems like, you know, kind of unplugging and holding your own counsel as opposed to taking in all arguments on every side from every particular portion might actually be a threat to what we hope the independence of the judiciary will serve. So I'm wondering how you balance that.
So we do have a way to balance that. So the question really has to do with how do we get input into the real world? I mean, and that's a fair question. The way that we do it is through Friends of the Court briefs. And in my case, as the chief, I decide which briefs will be accepted. And my policy is if it's not over length and you can state a legitimate basis, then you're in. And we encourage and we accept Friends of the Court briefs. So we get the perspective from all sorts of different folks who have knowledge, content knowledge, and they also frequently tell us, well, if you decide it this way, here's what's going to happen in the real world. And we can take that into account. So that's legitimate, and that's not being lobbied, and it's not, outside of what's appropriate for us to consider.
What if I'm just someone who's given some thought to it, maybe an isolated scientist, say, who might say this social science that this friend actually kind of put forward is pretty far-fetched, and in fact it doesn't seem to match the consensus of any reasonable social scientists. And this is what I'd like to send to you via email, but I don't have the ability to do so, say, through a Friend of the Court, because that takes time, money, etc. I'm just wondering what sort of protections there might be for that sort of situation.
Well, that's really not. It would I think jeopardize our ability to maintain our distance if we allowed unsupported, uncited individuals to write emails to us. So when a person writes a Friend of the Court brief, they have to have the support in either the literature or in the case law, and that's what we're looking for, because we rely heavily on what is called stare decisis. We try not to change the law in dramatic ways. We try to build on the past, and so we want to see what has gone before, and so we rely on citation to law and scientific articles. We consider those. So
a scientific article might be an ex post facto Friend of the Court brief?
Well, what happens is when it gets to the Supreme Court, we do our own independent research as well. And so if there's a law review article or a learned treatise, for example, which is called to our attention, we read those. But mainly the arguments of the parties, that's what we have to decide. But it helps to inform our context.
All right, thank you.
Yeah. Yes.
With the role that corporations put into elections, all local, state, and federal, do you guys see the role changing to maybe instead of just stepping between the individual and big government, maybe stepping between the individual and multinational corporations, for example?
Well, it's interesting. We have had a number of cases recently that have been the fallout of the mortgage lending crisis, right? The Bernie Madoff stuff. In fact, we just had a case that involved Bernie Madoff last week. So some of those things are working their way in, and they generally come to us through in the context of a consumer protection action. So the legislature passed what's called the CPA, and that protects consumers. And so oftentimes the complaint that's being made is made through that consumer protection statute. And then we're looking at, oftentimes it's at least national, if not international corporations that are kind of at the heart of some of these practices. And then it's up to us to look to see whether or not their practices comport with, like, our state. Our state has a security and exchange law, so we have our own state statutes on SEC. We have other statutes that protect, for example, in the arena of real estate and foreclosures. We have our own state laws. So we look to see whether or not they have their conduct comports with those provisions. Yes?
Do you think that electing justices as opposed to appointing them is at all a threat to the nonpartisan nature of the court?
This is the thing that I said would take probably an hour in itself, but it's interesting. When there was a real concern, probably 30 years ago, to 20, 30 years ago, maybe 30, about that issue, and so a lot of states started going to what's called a retention system, where you don't actually have, you're still elected, but all you are is retained. So on the ballot it says retain Justice Madsen or retain Judge Jones. And if you don't mark retain, then a new appointment is made. And people felt that that was a really good system because unless you did something really egregious, like, you know, beat your wife or something, you could probably stay in office and continue to do your job, and that gives you some independence because you're not fearful that you're going to be attacked. But the Iowa judges that I mentioned earlier were all retention judges, and they were not retained. So I'm not sure, given that big money can come into a retention election, it can come into a contested election. One of the things I understand is going on in some of the Midwestern states is that they're going to an appointment system with the Senate doing a confirmation, which means that, you can imagine, whoever is in political power in the governor's mansion is going to have an awful lot of sway over who that judge will be. So honestly, I don't think that there's one system that necessarily is better than the others. And I think it really comes down to the ethics of the individual. If the individual judge allows themselves to be swayed by these influences, then they're going to be swayed, whether it's a retention or a appointment or a contested election. In the back.
I was wondering if you could discuss, maybe you don't want to talk about it too much, but some of the challenges of campaigning to the public that doesn't really understand your position.
Yeah, you know, it's difficult because a lot of people, as I said in my remarks, people don't really understand the role of the courts very well. And so very often, I've campaigned now 4 times to be reelected to this seat, and I go out every time and I speak to members of the public, and I'm invariably asked about whether like for example this last time, do I support legalizing marijuana? Well, you know, I'm not going to legalize it. That's not my role. My role is to decide whether or not they, for example, did logrolling when they passed the initiative or the legislation. If it came from the legislature, if it came as an initiative, did they follow the rules for initiatives? That's the kind of thing. You know, ask me that question, I can answer you. But so I think there's a lot of misunderstanding about the role that courts are supposed to play. If I were knowing what I know, and I were voting for a judge, my question would be, do I think this person is going to be open-minded, follow the law as it's been written, and do their best to give meaning to the intent of the legislature and to the intent of the Constitution to the best of their ability? And if I could answer yes to that, I would say I got a winner. But that's not really how people think about it. So it's tough when you go out and campaign because they don't understand what your authority is, how you don't pass laws, that they can't lobby you, they can't send you emails. They don't really understand the role very well. And the courts do try to get the word out about what the role of the courts is supposed to be, but it is a challenge, mostly because a lot of people don't. I mean, here you all know there's 3 parts to government, right? But I think out in the public, oftentimes people can't name the 3 branches of government. So it's a challenge to run for a judicial position. Let me ask somebody else who hasn't asked a question. Yeah, go ahead.
This is a really similar question to that one, but about campaigning. You mentioned there are a number of unpopular decisions that you had to decide over time. When you are campaigning, and especially in this environment where people don't necessarily understand the role, do you find that, especially if you've recently made an unpopular decision, that you get a lot of pushback from that, or do they tend to fly under the radar? What's the dynamic there from the perspective of campaigning?
They don't seem to fly under the radar. Usually it's the Seattle Times editorial and the Tacoma News Tribune and the Spokane I can't think of the Spokesman Review. Thank you. So no, they don't fly under the radar. I think before 2 of my elections, I had made very unpopular decisions, and I had written them. One had to do with a case called State versus Andrus, and it was the felony murder rule, and the media went crazy saying that the gates of the prisons would be thrown open and all the murderers would be set free. This was the line. Anyway, no one went free. Everyone was retried, or they agreed to a plea to a manslaughter instead of felony murder. Some decided to go back to trial, and they did worse. They got actual murder, second-degree convictions. I mean, it was just hype and media, frenzy. But people believed it, and so I had to talk about the issue. And it was a hard issue to talk about because it was kind of complex. I mean, why I came to that conclusion. But what I found was that the people who cared to listen all came away saying, well, geez, that was a tough decision to make, but it sounds like you made the right decision based on what you knew. And the other one was I wrote the majority in the gay marriage case, and there were a lot of people who were very unhappy with that. And again, I had a lot of friends that didn't understand how I could write that case. But again, so I spent a lot of time explaining the Constitution and the fundamental rights and how that plays into the level of scrutiny that you apply to legislation. So, yes, I mean, I find that it's exhausting, actually, to campaign right after a tough decision like that because everybody is in a tizzy about what you've done. But again, once you explain how you read the law and what the law, as far as you understood it, says and why you did what you did, people do tend to kind of calm down. And I got support from the people that I expected support from once I had explained it. Yeah.
Are there any areas of statute law that you or the Supreme Court feel are inadequate or insufficient? And if so, could you mention some?
Well, what I'll say is this. Every year, I'm required as the Chief Justice to send a list of errors and omissions to the governor. And that includes laws which we think are inadequate or so difficult to understand that we don't feel that we're doing justice to the intent of the legislature. And since I became chief, I felt like we really needed to enhance our role in informing the legislature about these errors and omissions. And so we now have a pretty robust process in place where the courts of appeals judges and the Supreme Court justices watch for these cases over the course of a year and collect cases where the statutes are inadequate. And then I compile the list. I explain why the problem exists, or in our view, why there's a problem. And then I send it to the governor, and I also send it to the four corners, which would be your House and Senate majority and minority leaders. And they can do whatever they want with it, but at least I feel like I've done my job to try to. Again, we're not hermetically sealed between the three branches. We're supposed to kind of flow, and I think that's one way we can flow. We can help each other by informing each other of the things that need to be improved.
Is that information available publicly?
I don't know. Probably a public information request from the governor's office would net that for you.
I think we've got time for one more question now.
Yes.
As you mentioned earlier, sometimes you have to throw down an issue that because the local government is trying to supersede the reach of the state law. How do you feel about the state's role or the judiciary upholding of state laws passed or reaching past the federal level? As you talked about decriminalization, where you're in the same situation on the other side.
So I'm not sure that we've actually had to face that yet. I mean, I see the potential, particularly the marijuana laws. I mean, I'm sure you're thinking that in particular. And it really depends upon the form that the issue takes. So we were one of the first states, of course, to pass the medical marijuana initiative. And so that kind of got us a little bit crosswise with the federal regime, but not so much as what we have now. And of course, now we have our Attorney General, who's going to be here, I guess I heard. You should ask him this question. But he went back to the Department of Justice to actually try to work out a compromise so that they wouldn't be prosecuted here. And we're in the throes of trying to figure out what to do with our lawyers, for example, who are assisting these people who are arguably, and more than arguably, breaking federal law, right? So it hasn't, none of these issues has reached our court in a way that requires us to wrestle with just exactly what you're saying. I don't know what we're going to do. It's a conundrum. So.
Well, unfortunately, we're out of time now. So I hope you can join me in thanking Chief Justice Barbara Madsen. So I hope to see some of you here on Thursday or Friday. Well, not me. I'll be out of the country. But other people will be.
Oh, if I sit down, somebody might jump on me. Yes. Oh, I'd be happy to. Sure.
Yeah, sure.